So today I'm going to present a legal case with citation number 19F3D 1418 between Zenith Laboratories and Bristol Myers Squibb Company back in 1994. So the major dispute between these two companies is concerning a drug called ceftriaxone. Ceftriaxone is an antibiotic drug for bacterial infection resistant to penicillin. Its original patent was held by Bristol Company, which already expired in 1987. However, Bristol Company got another patent approved for a special formulation format of ceftriaxone called benzyl monohydrate. This is patent 657. In 1991, Bristol Company filed a lawsuit against a Spanish pharma company called Gamma for patent infringement of 657. According to Bristol Company, Gamma was manufacturing and trying to market in America a special formulation format of ceftriaxone called ceftriaxone DC. Although ceftriaxone DC is structurally different from benzyl monohydrate, Bristol believed that under the doctrine of equivalent for patent law U.S. Code Title 35, ceftriaxone DC is essentially equivalent to benzyl monohydrate and therefore is covered by the 657 patent law coverage. Further, Bristol found that when patients are ingesting ceftriaxone DC got converted into benzyl monohydrate in patient's stomach and therefore induces patent infringement. Following the lawsuit, Gamma gave up the plan marketing ceftriaxone DC in America and therefore leading to a lawsuit dismissal. However, in 1994, Zenith Laboratories, the American contractor of Gamma, initiated a declaratory judgment action towards Bristol Company in Maryland District Court, trying to re-examine the patent infringement of ceftriaxone DC against benzyl monohydrate. Zenith argued in two ways. First, they believe that the doctrine of equivalent does not apply to ceftriaxone DC, since when Bristol Company was applying for their patent 657, they narrowed down their patent coverage statement to accommodate the patent law. Therefore, Bristol has already given up the ability to broaden their patent law protection range to cover equivalent. This is called prosecution history estoppel. Secondly, under the technology limitation back in 1994, Zenith Laboratory believed that there's no enough scientific evidence showing that ceftriaxone DC has been converted into benzyl monohydrate in patient's stomach. So this court was brought into the Maryland District Court, and Bristol Company replied that first, there's no enough evidence showing that they have already given up the ability to broaden their patent law coverage for 657 to cover ceftriaxone DC as an equivalent. Secondly, the chief scientist from Bristol Company called Dr. Harold Britton has persuaded the judges from Maryland District Court that using his cell work to mimic human stomach environment, ceftriaxone DC has already been converted into benzyl monohydrate. So this led to Maryland District Court's conclusion that patent infringement has occurred and Zenith Laboratory cannot market the drug in U.S. until 2002, which is expiration date for patent 657. Zenith Laboratory then appealed to the federal court. During their examination of all the testimonies and evidence presented in Maryland District Court, the federal court has found that Dr. Harry Britton has made a major mistake in comparing the extray structures of ceftriaxone DC and their patented benzyl monohydrate. Dr. Britton used a reference compound instead of benzyl monohydrate to compare the product's extray structures to ceftriaxone DC. Therefore, the federal court has concluded that the evidence provided in Maryland District Court was failed to show that ceftriaxone DC will be converted into benzyl monohydrate in patient's stomach, and Zenith Laboratory reversed the decision from Maryland District Court and they won the case.